Hello, I am attorney Masa Sam Foray, owner and founder of the Foray firm with offices in Chicago and in Houston. And I am back today to talk to you about all things related to Illinois family law. So today's question is, I live in Chicago, but I want to move with my child to Atlanta. Can I do so? So the short answer is you can do so if you have agreement from the other side. So the section of the statute that's going to deal with the issue of relocation, which we used to call removal, is section 609 of the IMDMA. So section 609 of the statutes deals with the issue of relocation. And in summary, what that statute says is that you would have had to give 60 days written notice of your intent to relocate. And once you gave 60 days notice of your intent to relocate to Atlanta, that would have given the other side, or your children's, mother or father, the opportunity to then object or file the necessary petitions in court to restrain you from leaving the state. That's the reason for the 60 days notice. If they object, or if you do not get approval from them and actually, confirmation of that approval, then you can't leave. You can't move more than 25 miles away from where your current residence is. So it's not just a matter of that moving out of state, but the way the 609 statute is written, you cannot move more than 25 miles from your current residence. Because think about it. In the Chicagoland area, 25 miles from your current residence could have you in a completely different zip code, a completely different school system. It could have you in a different county, and it could be the difference of a driving time between your two residences of an extra 20 minutes or an extra 2 hours, depending on traffic patterns. And so Section 609 is really set in place, again, to make sure that children have ready access and equitable access to both parents. So if you don't get an agreement from the other side, and if you're forced to, to litigate this matter, then just make sure that you do so and that you don't just get up and leave. Because what happens if you just get up and go? You get up and pack the child up and you move more than 25 miles, let alone all the way from Chicago to Atlanta. What remedies does the other side have? Well, the other side has a lot of options. At that point, they could go to court on an emergency order of protection and ask for the immediate return of the minor child. They could ask for you to have no contact whatsoever with the minor child while the order of protection is being adjudicated. In addition to that, a skilled attorney like myself might go in on an emergency motion for temporary and permanent allocation of parental responsibilities, which we used to call custody, or an immediate return of the minor child to the state of Illinois. And let's be clear, that would be an immediate return of the minor child, not your return, because nobody can force you to return to the state of Illinois. But imagine the conundrum that you would be in if you got up and you relocated to Atlanta, you got a new home, you got a new job, the children, were enrolled in school, and then you had an order enforced from an Illinois court whereby your child had to be returned back to the state of Illinois, and by way of that then returned or turned into the custody of the other parent. So it's quite a can of worms. A lot of people have this natural instinct to want to protect themselves and separate themselves from what would have been a difficult past relationship. But when you have children and when you have a court that has jurisdiction over those children, you do have to make sure that you're paying attention to the laws. So if you have to go to court and you have to file a petition for relocation, let me just tell you what the statute says. A summary of this, again, this is 609 of the Illinois Family Law Statutes. A summary of that says that you would need to show a number of different factors to the court to prove why it would be in your child's best interest to relocate with you to Atlanta. Some of the factors include that there are better educational opportunities for the child there. It might be that you have better, job security, economic security. Not that you were just looking for job options, but that you specifically had been given a job offer in your company or in a different company that would significantly increase your earning potential and was directly tied to the progression of your career. Some other factors that the court might look at would be whether or not you had family, close extended family that was your main source of support for you and for your child. If you left the relationship where you two were an intact family in Chicago, but in actual fact you were originally from Atlanta and you had all of your family and your support system in Atlanta, and you needed that support system to surround you and to support you in your now new journey as a single parent. Those would be some of the compelling factors that you would want to demonstrate to the court to make sure that you were successful in your 609 petition. In any event, I can tell you that on the echelon of cases, with the easiest cases being, perhaps a simple, child support matter where the court is just doing calculations. And then the more difficult cases, when we start getting to complicated custody or allocation issues, removal is on the very far end of the scale of difficulty, because the natural inclination for any family law judge is to make sure that children have access to both parents. So, if you are in a situation where you have compelling reasons to move to Atlanta and you need to file a 609 petition because you did not get agreement from the other side to move, I strongly encourage you to reach out to a trusted family law attorney who will be able to help you achieve your goal in being able to relocate with your child. I hope this has been helpful.